Welcome back to the Deep Dive. We take complex stuff, break it down, and give you the knowledge you need pretty fast. Today, we're actually looking at the infrastructure of knowledge itself. The subsidies keeping internet flowing to schools, libraries, all across the country.
Right, it's a vital network.
And we're diving into a specific recent Supreme Court decision. It's Wisconsin Bell versus Heath. Now, this case, it sounds technical, involves fraud allegations, but it boils down to one big question.
Which is?
When is money considered government money? Especially when you're talking about fighting fraud, even if that money didn't exactly start out, in the Treasury. Our mission here is to unpack this legal fight using really clear language.
Okay, so this all centers on the E-rate program. That's the education rate program. It's actually huge. It started back in the mid-90s under the Telecommunications Act.
And his job is basically discounts, right?
Yeah, essentially. It gives schools and libraries subsidies, discounts, anywhere from 20% up to, believe it or not, 90% off their telecom service costs. Think internet access, that kind of thing. It's critical for, connecting classrooms everywhere.
But the way it's funded is, well, it's unusual. And that's kind of the heart of this legal problem, isn't it? It's not paid for directly out of, federal income taxes.
Exactly right. E-rate gets its money from mandatory fees, telecommunications carriers, the phone and internet companies. They have to pay into something called the Universal Service Fund, the USF.
Okay, mandatory fees.
And here's the twist. That fund, the USF, it isn't administered by a government agency. It's handled by a private nonprofit corporation. It's called the Universal Service Administrative Company, or USAC.
Okay, hold on. So you've got what seems like private money fees from private companies being handled by a private organization, USAC.
Yeah.
So how does the government step in to fight fraud against that fund?
Well, that brings us to the other key piece, the False Claims Act, the FCA.
The FCA, right.
This is the main legal tool here. It's actually an old law, dates back to the Civil War. It lets private citizens, whistleblowers, basically, like the auditor in this case, sue on behalf of the government.
To protect federal funds.
Exactly. To protect federal funds from fraud. If someone knowingly presents a false or fraudulent claim, they can be hit with serious liability. So the whole fight here is whether the money USAC pays out to carriers. Does that actually count as the kind of money the FCA is supposed to protect?
Okay, let's unpack the specific fight then. The allegation was against Wisconsin Bell, a telecom carrier.
Right.
And the claim was they defrauded this E-rate program. Millions of dollars, right? Between, 2002 and 2015?
That's a time frame, yeah. A long period.
But for fraud to happen, they had to break a specific rule. What was the mechanism here? How did this alleged fraud actually work?
The key is a specific FCC regulation. It's called the Lowest Corresponding Price Rule, or LCP rule. You can think of it as the main guardrail for the whole E-rate subsidy system.
Lowest corresponding price.
Right.
Okay, what does that mean in simple terms?
It means a carrier, like Wisconsin Bell, can't charge a school or a library more for a service than it would charge a, quote, similarly situated non-residential customer. Basically, no price gouging just because it's a subsidized program.
Okay, let's try to make that concrete. Maybe use the numbers from the case materials.
Sure. Let's imagine the actual lowest price a service should cost under this LCP rule is $1,000. And let's say a school gets a 60% E-rate discount, a subsidy.
Okay, 60%.
So the Universal Service Fund via USAC should pay the carrier $600, right? 60% of $1,000. The school pays the remaining $400.
Makes sense. But what did the auditor, Todd Heath, claim Wisconsin Bell was doing instead?
Heath claimed Wisconsin Bell would inflate that starting price. Instead of the true $1,000, maybe they'd tell USAC the price was $1,500. This violates that LCP rule.
Okay. And if the subsidy is still 60%?
Now the E-rate fund pays out 60% of $1,500, which is $900.
Instead of the $600 it should have paid.
Exactly. The carrier pockets an extra $300 directly from the fund on that one transaction, just by inflating the base price. They submit a reimbursement claim based on a false price. That's why the LCP rule is so central. Violating it is how you could potentially fleece the fund.
Okay, but Wisconsin Bell's defense wasn't really about whether they did that, at least not initially. They tried to get the whole lawsuit thrown out on a technicality, right? Challenging the very definition of a claim.
That's right. They went straight for the structure of the E-rate program itself. Their argument was, look, the reimbursement request, the claim, it goes to USAC.
The private company.
Right. Another recipient, not the government directly.
Right.
And the False Claims Act has a specific requirement for claims made to these other recipients.
What's the requirement?
The claim is only valid if the government provides or has provided any portion of the money requested.
Okay, so if the claim goes to USAC, the private entity, how could this government anti-fraud law, the SCA, which protects federal money, how could it even apply? That seems like the core issue.
It was absolutely the core issue, a potential showstopper. Wisconsin Bell basically said, this money comes from private carriers paying mandatory fees. It's handled by a private company, USAC. The government, they argued, doesn't provide a single penny to the fund itself.
So therefore?
Therefore, the FCA doesn't apply. Case dismissed. Millions in potential fraud liability gone.
And this wasn't just some, obscure legal theory they cooked up. This exact question had split the federal courts, hadn't it?
It had a major circuit split, which is often why the Supreme Court takes a case. The Seventh Circuit, which handled this case initially, had said, yes, the government does provide the funds because it controls the program so heavily.
Through regulation.
Through intense regulation, yes. But the Fifth Circuit, in another case, had ruled the opposite. They said, nope, just regulating isn't enough to turn private contributions into government money for FCA purposes. So you had conflicting rulings across the country, a big mess.
Right. So the Supreme Court steps in, they look at this whole mess, and they actually reach a unanimous decision. They agree that these E-rate reimbursement requests are claims under the FCA.
Yeah.
But how they got there was interesting. They took a really narrow path, didn't they?
Extremely narrow. Justice Kagan wrote the opinion. They deliberately sidestepped that huge question of whether government regulation alone makes the money federal.
Okay, so if they didn't rule on the regulation part, how did they decide the government provided the money?
They focused purely on tracking actual money transfers, specific dollars. The key finding was that the government did provide, and they defined provide simply as supplied, furnished, made available, a portion of the money involved.
A portion? How?
Because they found the U.S. Treasury had directly transferred over $100 million into the Universal Service Fund during the years the lawsuit covered.
Whoa, okay. Over $100 million from the Treasury. But we said it wasn't funded by taxes? So where did that specific $100 million come from?
Good question. It came from two main sources, both involving direct government action using its legal powers. First, about $50 million of it came from collecting delinquent contributions.
Meaning carriers who didn't pay their mandatory fees?
Exactly. When carriers just refused to pay into the USF, USAC, the private company, couldn't always force them. So the FCC and the Treasury Department had to step in. They used federal legal authority to force collection of those overdue payments, plus interest and penalties.
Okay.
That money they collected was deposited into U.S. Treasury accounts, and then the Treasury transferred it over to the Universal Service Fund.
Ah, so the government actually had to go get that money using its power. It wasn't just passively flowing from carriers.
Precisely. The government generated that chunk of money through its enforcement actions. The second source, also around $50 million, came from Justice Department activities.
Like prosecutions.
Yes. Prosecuting E-rate fraud specifically. When the DOJ pursued cases, got civil settlements, or collected criminal restitution payments related to ripping off the E-rate program. Again, that money went into Treasury accounts first.
And then the Treasury transferred it to the fund.
Yeah, and transferred to the fund. So you have these two distinct streams totaling over $100 million that physically pass through the U.S. Treasury because of direct federal enforcement and collection efforts.
Okay, but Wisconsin Bell still argued, hold on, even if it passed through the Treasury, the government was just like a middleman, a conduit. It didn't originate there. They called the government a passive throughway.
They did, but the court didn't buy it. Not at all. Justice Kagan used some really clear analogies to explain what it means to provide something, even if you didn't originally own it.
Like what?
Like a proctor at an exam provides the blue books and pencils to students, even though the school probably bought them.
Okay.
Or a bank teller provides you money from your account, even though it was your employer who deposited it.
Right, or the UPS driver example they used.
Yeah. A UPS driver provides you a package, even though they didn't buy the contents. The act of furnishing, supplying, making available, that's providing.
So the court is saying, basically, the government using its authority to get that money by forcing collections or prosecuting fraud and then physically routing it through the Treasury is the act of providing. That action satisfies the law.
That's exactly it. The government wasn't passive here. It actively generated this specific $100 million plus portion through its unique powers of enforcement and collection. That action, plus the transfer from the Treasury, met the FCA's requirement that the government provide any portion of the money. The question of who originally owned the dollar became irrelevant.
So the bottom line is Heath's fraud lawsuit against Wisconsin Bell gets to go forward. But as you said, the court got there by carefully stepping around some really big legal landmines. What are these huge, unresolved questions they deliberately left for another day?
Yeah, the concurring opinions, especially from Justices Thomas and Kavanaugh, really highlight these. The first massive question they dodged was that broader regulatory theory.
Whether just mandating the payments is enough.
Right. Does the government provide all the money in the fund simply because it passed a law requiring carriers to pay in? The court didn't answer that.
And why is avoiding that so significant?
Well, Justice Thomas warned that if the court had accepted that broad theory, it could blow the doors wide open on the False Claims Act. Suddenly, almost any situation where the government requires one private party to pay another could potentially fall under the FCA.
Like what kind of situations?
He mentioned things like maybe state-mandated child support payments processed through state agencies, or think about private health insurance claims under heavily regulated federal programs like the ACA. If just regulating the payment flow means the government provides the money, the FCA's reach could expand dramatically into purely private transactions.
Wow, okay, that's a big one. What was the second major issue they avoided?
It relates back to USAC, the private administrator. The court did not decide whether USAC is legally an agent of the United States.
Why does that matter?
Because if USAC is a government agent, then technically a claim submitted to USAC is like submitting it directly to the government. That would automatically satisfy the FCA definition. No need to trace the $100 million.
Seems simpler. So why avoid it?
Because, as Justice Thomas pointed out, if USAC is deemed a government agent, well, that could make the entire E-rate program structure potentially illegal.
How so?
There's another law, the Government Corporation Control Act, GCCA. It basically says you can't create new government corporations without specific approval from Congress. The FCC deliberately set up USAC as a private nonprofit precisely to avoid violating the GCCA.
Ah, so if the government now argues USAC is really an arm of the state just to make this fraud lawsuit work,
they might be accidentally undermining the legal foundation of the whole E-rate funding mechanism they created. It's a huge structural conflict. The court punted on resolving that. It'll likely come back.
And we should probably mention Justice Kavanaugh's point too, right, about the lawsuits themselves.
Yes. He added a concurrence basically flagging a fundamental constitutional issue with these Plum lawsuits overall. That's where private citizen sues on the government's behalf. He noted that this structure raises substantial constitutional questions under Article 2 about the separation of powers, essentially. Who really holds the executive power to prosecute claims for the U.S. government? That bedrock issue remains unsettled.
Okay, so let's wrap this up. The key takeaway for you, the listener, seems to be this. A very specific, almost technical detail about how the Treasury handled money, that $100 million minimum that came from collecting debts and fraud settlements. That was the crucial key. It allowed this fraud case to move forward without blowing up these larger legal questions.
Right. It was the narrow path. It proved concrete federal involvement tied to specific dollars, bypassing the need to decide if regulation alone equals federal control. And it means that even for these programs mainly funded by private industry fees, if the government has to step in using its enforcement powers collecting debts, prosecuting fraud related to the program, that action effectively brings the program's funds under the protection of the False Claims Act.
Which leaves us with a pretty interesting, maybe provocative thought for you to consider. Does the fundamental nature of money, whether we call it public or private, actually change based on whose bank account it flows through, or whether the government had to use its muscle to get it there?
The Supreme Court's answer here, focusing on the action of providing and the path through the Treasury, suggests that maybe the context of how money moves and the power exerted to move it matters just as much, if not more, than where the dollar bill first came from.
A fascinating idea, especially as these kinds of public-private funding arrangements become more common.
Definitely something that's still evolving in the legal landscape.
All right, that's our deep dive for today. Thanks for joining us. We'll see you next time.